our first speaker is Kevin Green, an attorney at Halloran Sage, who's focused his entire career on employment law, including handbooks. So that's what he's going to talk about today. And hopefully a lot of you know that Connecticut law has really undergone a lot of changes in the last year, specifically with respect to employment laws, and many of those will maybe make their way into your handbooks. So join me in welcoming Kevin Green. Green goes forward.
Good morning. Again, I'm Kevin Green. I'm from Halloran Sage, and just want to thank CBIA and SHRM for having me here to speak at today's conference on a topic that's near and dear to my heart, and I'm sure yours, and that's our employee handbook. I thought Diane's comments were fantastic to open the conference. We need to sit and reflect and learn and develop our skills, our knowledge, our expertise, and you need to take that time. And also in terms of the challenges that we face day to day, certainly the employee handbook can serve as a resource to you as well as your employees in terms of trying to navigate some of these life challenges that employees face, changes in the law, and to the extent that we can keep our handbooks updated to give us a roadmap to be able to make some of those decisions, to provide some guidance to our employees is important. I am going to talk about some law today, but also I want to try to talk about different considerations in terms of the handbook. You know, I think as we go along, we kind of have the handbook. A lot of times we don't think of it as an integrated, holistic document. We're always kind of flipping right to one section, and we look at that section and we think we answered the question or we have what we need, and then we're on to the next task. And I think a lot of times we need to kind of sit back and reflect on our handbook as a whole. And what does it say about our company? What does it tell our employees? Is it consistent? Is it updated? Is it really what we want to rely upon and what we want our employees to think about our company? So I'll point out some things, I'll ask some questions, and I certainly, as we go along, I would encourage you to ask questions. You're welcome to take questions from the conference, from the audience on specific topics. If I think it's going to be a more involved answer to your question, then we may table that. I'll be here this morning, and we certainly can have a discussion. I also, my contact information is in the materials, and please feel free to call me for some free advice in connection with this conference. If you wanted to ask me a question about a handbook, if you had an email that you wanted to send me just to ask me a quick question, I'd be happy to speak with anyone as a service to CBIA for having me here today about any topics related to employee handbooks. So please feel free to reach out. I think the first question to ask is, when is it time for an update to your handbook? What's a good time? I would say that as a general rule, that 6-month to 2-year range, I probably would not go more than 2 years at least without reviewing the handbook, and that's really kind of out there. I mean, going 2 years without reviewing and updating your handbook there's a risk there. I think that my experience has been that most of my clients take a look at their handbook yearly. I encourage them to look at it yearly or even semi-annually every 6 months and take a look at it. I think that, when there's major changes, when you go to a conference like this or you talk to a human resource professional or an attorney, or you learn something or you get an update, I mean, that's certainly a time to not only check out and update that specific provision, but take a look at your entire handbook and see what else perhaps needs to be updated. Obviously, if there's major changes as we've had in the last 2 years in terms of hiring, in terms of our workforce, turnover, policies, people now working from home. Certainly, those are, I'd say, crises events that definitely merit taking a look at your handbook and making updates. The other issue is if you've got common problems, you have the same question about a wage and hour issue from a bunch of different employees, or a common one now is, a lot of people have accrued a lot of PTO, and, what are we going to do? Are they going to roll over their PTO? How are we going to account for that? If you're starting to see those kind of problems, those types of questions, managers are asking the same question about how to deal with an issue, well, that's a trigger for you, a signal that we probably should update the handbook to address that issue. Obviously, litigation, and I do a lot of litigation. Probably 60% of my practice is defending employment cases in all different forms: CHRO, state court, federal court, NLRB, pretty much anywhere, unemployment, anywhere that an employment case can be litigated. And I see a lot of issues with handbooks, either somewhere where the handbook actually saved the day, believe it or not, or the handbook was used against us by a crafty plaintiff employment attorney who scrutinized our handbook, quite frankly, knew it better than the employer, and has used it against us. And that's a time to make adjustments to your handbook. But I would say now is definitely a good time. I mean, given what we've dealt with over the last 2 years and all the dynamics of our workforce that have changed, and quite frankly, the place, the venue for work has changed so significantly that is a time to update your handbooks. So the good news is there's job security for your human resource employees and attorneys. The bad news is that we do have a lot of work to do. So I think the first question fundamentally that you have to ask yourself is, why do we have a handbook? Or do we need a handbook? I think a lot of people sometimes are surprised to find out that a handbook is not required by law. There's no Connecticut law or federal law that says that you have to have an employee handbook. And I have plenty of clients who have managed their human resources quite effectively without an employee handbook, and they usually use a series of 5 or 6 key forms that they keep updated, and they have new hires sign off on them. They have existing employees sign off on the updates. They keep the copies of the policies signed off on by the employees in the personnel file. They may post them on an intranet or somewhere on their company website with access to the employees, but they don't have an employee handbook. My own feeling is that in the end, you're better off with a handbook, particularly when you start to get above, say, 15 or 20 employees. I think in a smaller office, sometimes you can manage things without having an employee handbook. But as you start to get to have more employees, more issues are raised, there's more questions, more problems, more discipline, more people who maybe push the envelope in terms of what the expectations and requirements are of the office. That's when you need to start to standardize your policies and procedures in an employee handbook. And I think when I ask that question about, well, do we really need a handbook? I think a lot of times people think to themselves, well, why wouldn't you have a handbook? Why wouldn't you have one? I will tell you, and this is really lesson learned from litigation, that having a bad handbook is far worse than having no handbook. And when I say a bad handbook, a handbook that has kind of sloppy language, language that can be used against us, and we'll talk about some of the ways that handbook language can be used against us. A handbook that, quite frankly, is not tailored to the specific needs of your business. I think that, I don't see this as much now, but I think that 10, 15 years ago, there were standard versions of handbooks that kind of floated around in a business, probably not a human resources professional, maybe an owner, maybe someone who was more an operations person just said, oh, well, we'll just use this XYZ company handbook, and that'll be our handbook, and we'll put our logo on it, and that's what we'll use. If your handbook does not reflect your current policies and procedures, expectations, how things are done in your business, it's actually worse to have a handbook than to not have one. I'll just point out some language that I've seen in handbooks that have created huge problems in litigation, and we'll do a little bit more of this, but I've seen provisions in handbooks saying, you must be physically able to perform all functions of your job on your own. That type of language is going to be used against you in litigation in an ADA, reasonable accommodation case. That is not the law. Management reserves the right to terminate for just cause. That's a provision that sometimes you'll see in a handbook, and that creates now, arguably, an obligation of the employer you've basically taken yourself out of at-will employment, and you've now created a just cause standard that you've imposed on your company. Now, in a collective bargaining situation, you're probably going to have that already. But if you're not a collective bargaining company, you're not a unionized workforce, but you put in your policy, your handbook, that terminations will be for just cause, you've now taken yourself out of at-will and created a situation where you need to show just cause in order to terminate someone. I've also seen provisions that say, no one will be paid for working overtime without permission. And certainly you can require employees to get permission to work overtime, but I think as most of you know, you cannot say to an employee, well, if you worked overtime without permission, I'm not going to pay you. You have to address that through discipline. You can discipline that employee. You can give them a warning. You can give them a suspension, counsel them, terminate, I guess, but you can't say to them, well, you're not going to get paid for the hours that you spent working overtime without permission. So those are the type of that's some of the language that I see in handbooks when I say this is a quote-unquote bad handbook and you're better off if you didn't have it. So that's the kind of language that you want to scrutinize in your handbook. One of the other things for smaller employees, having a handbook is going to limit the discretion that you may be able to exercise in terms of making some decisions, particularly if you're going to set forth a very rigorous progressive discipline policy in your handbook, but then you're not going to follow it. You've now created some problems. You set that progressive discipline policy, but you're going to make a lot of different exceptions. That creates an issue for you. So if you're a smaller employee and you like to be able to have that discretion to kind of tailor specific discipline to an employee's work history, the circumstances that led to the reason for the discipline, the needs of your company, sort of the corporate culture or business culture of your workforce and of your company, maybe you want to think about whether you really need a handbook. The handbook also offers inside information about your workforce and about your business practices to your competitors as well as the union. If you're a target of union activity, the first thing they're going to do is they're going to get your handbook and they're going to scrutinize that handbook. And this is also a reason why you want to make sure your handbook is updated and it's legal and it's compliant and that the language is strong. But keep in mind that that's what a union is going to do. They are going to get your handbook. They're going to look for National Labor Relations Act Section 7 violations. They're going to look for language that seems onerous, that perhaps your competitors and other businesses aren't imposing on their employees, and they're going to try to leverage that with your employees to show them, hey, this isn't fair, this is what your employer's doing. And I mentioned that there's certainly a risk, a danger to just using another company's handbook. I'll also say, sort of as a caveat, so I supplied some policies that Diane had asked me to provide. So I included a sexual harassment policy in your materials. I included a work from home, remote work policy in your materials. And I included a kind of revised and very sort of rigorous drug and alcohol policy in your handbook, reflecting kind of the update for legalization of marijuana and the impact on the employer. Those policies may not necessarily fit your business, so I'm not saying you should just take those policies and put your name on it and use it. You certainly can. If you look at it and you feel it's appropriate, feel free to use those policies. You can also call me and we can talk about how to tailor those policies to your specific workforce and your company. But be careful just kind of blindly adopting some policy that a lawyer's given you or that you found and that you want to use. Make sure that it's tailored to your specific needs. So now we'll talk about just some of the top reasons to have an updated handbook. Obviously, the first reason is so that your employees know your policies and procedures, both new employees and existing employees. You want them to know what your basic rules and procedures are. You want them to know when things have been updated. And you want them to ask questions, and they won't know what questions to ask until they kind of know what the policies are. I also think, to echo Diane's comments, we know that our employees deal with a lot of challenging life situations and that impact on their work. A lot of times, and we know who they are, there are employees who are reluctant to come to human resources to ask questions, and we have the people on the other end of the spectrum, but there are people that are reluctant to come and ask questions, hard questions, difficult questions. And sometimes that handbook, as they're sitting there at 9 o'clock at night trying to figure out what do they need to do to take medical leave, to have clear procedures in place in your handbook that they can see, oh yeah, okay, that's how I do it, that's what I need to do, that actually seems manageable. That can be some comfort to them, it can be some relief to them, and it certainly helps you do your job when the employees are educated about what they need to do. I think the employee handbook is a great opportunity for you and your ownership of your company to kind of get out your mission statement directly to your employees, to talk a little bit about the history. I always like getting a handbook. I read and review a lot of handbooks. I love reading about the history of some of these companies. And I think that, as employees, and some of the statistics that Orlena put up there, employees, they want to know that they're coming to work every day for more than just, their paycheck. I think that there really is a sense from employees that I get that they really want to know that there's something more than that. Now, the paycheck may be the most important thing to them, but there is some value in them understanding what type of an organization am I part of? What's the history of this organization? Why was this organization or company even created in the first place? So it's a good opportunity for you to get that message across. Obviously, you want the employees to understand the company's expectations, so not only the policies and procedures, but what are the expectations day to day in terms of attendance, in terms of timekeeping, in terms of wage and hour issues, leave, vacations, PTO, things of that nature. Certainly you want the employees to know that. The employee handbook also serves as a resource for your managers, your rank and file managers and supervisors, to be able to understand what they should be talking to employees about, what they should be saying to employees about certain issues. Maybe when they're stepping maybe a little bit over their area and they should be deferring to human resources. But you can use that handbook as a guide to educate and train your own manager. So it's not only for your employees per se, but also for managers and supervisors. You want to use that handbook. It certainly does help. A good handbook certainly helps us defend in litigation. If we can say, hey, this wasn't left to someone's discretion. This has been our policy. It was communicated to the employees. All the employees knew what was expected. All the employees knew their rights. All the employees knew they had a right to make a complaint about sexual harassment. They all understood that they would not be fired or retaliated against for making that complaint. Or they knew that if they participated in the investigation and gave a statement as a witness, they would not be retaliated against. So we can kind of use that prophylactically to take away some of the gray area when a case comes down to sort of witness credibility about, well, this was said, that was said, this was what I was told, the policy. No, here's the handbook. You read the handbook. The handbook actually encouraged you to read it. You got an opportunity to ask questions. And we'll get to this in a bit, but I think most litigators will say that we prefer the old school, hand-signed, dated, printed name acknowledgement of receipt on the handbook or whatever the policy that's being distributed. I know it creates a lot of challenges, particularly if you have a large workforce. It's a lot easier to just scan it as a PDF, send it as an email to all the employees. They all got it. When we get to litigation, it's a lot harder to prove that that employee received that handbook, opened it, read it, understood it, had an opportunity to ask questions. That becomes human resource professional saying, well, yeah, of course, I sent them an email. They all had an opportunity to read it. The employee says, oh, I got it. I got 20 other emails that day. I probably didn't read it. I didn't know what was in there. That's the type of gray area that if we take the time to do the old, distribute it, have them sign it, even sit down with the new employee and go through it, ask them if they have any questions, have them sign off on it. We have the signature. Then when we have them in the deposition, we can present that. And I know that these are issues that plaintiffs' lawyers that represent employees, these are the issues that they're looking for when they evaluate a case. Finally, we can use our handbook to provide legally required notifications. As we know, there are certain requirements that we post and distribute information to employees, sexual harassment language or sexual harassment provisions most recently in the last couple of years under Connecticut law have to be distributed to the employees. Your handbook is a perfect opportunity to check that box. In addition to posting it, in addition to reviewing it when an employee is hired, have it in your handbook and you can show that that requirement has been met. Just to outline the basics of an employee handbook, typically the structure that I use is I have an introduction, history, company message. We have our at-will employment disclaimers. Nothing in this handbook creates an employment contract or any guarantee of employment. This handbook does not alter the employee at-will relationship with the employer. I always have an equal employment opportunity policy in there. I usually then address sexual harassment policies, discrimination, anti-retaliation provisions, and ADA reasonable accommodation policies. I then usually include a section on expectations in the code of conduct for employees, attendance, our cell phone policy, our dress code if we're still adhering to a dress code, how do you report workplace injuries. I have a workplace violence provision in there, your drug and alcohol policy, as well as your discipline policy that you're going to follow. I usually then include a section on compensation, work schedules, time recording, an exempt versus non-exempt employee, classifying employees on that basis. Probably a good spot for your work from home policy, reviewing your wage and hour requirements if you have specific rules regarding timekeeping, clocking in, clocking out, getting permission to work overtime, things of that nature. How you're going to handle performance reviews. And then this is also where I would include some disclosures on the new pay equity and salary range laws, and we'll talk about those in a bit. And then finally, I would have a section on your leave policies. New updates on FMLA, Connecticut FMLA, how to apply for Connecticut paid FMLA, sick days, holidays, PTO policies, pregnancy accommodation, and maternity leave if you have a maternity leave policy. So we talked about these already, but some of the risks of having a poorly drafted handbook. if your policy, and I won't, we talked about most of these, but if your policy is not followed, you're going to give rise potentially to what would be called the breach of express or implied contracts, or misrepresentation or promissory estoppel claims. Employees are going to say, well, I relied upon that provision in the policy. I did what was called for under the policy, or that particular expectation or requirement was not set forth in the policy, and I'm now being disciplined or some adverse job action is taken against me. And that's why it's important to make sure that your policies are being followed, that the actual rules and policies in place in your workforce and with your managers and supervisors are reflected in your handbook. And we talked about in the beginning, kind of reading through, like taking that handbook, and rather than going to it to try to answer a specific question sort of in the abstract, just read the document. I mean, it may put you to sleep, but read the document. Take some time to just read it through, maybe even without taking notes, and just kind of thinking about it. Have your managers read it and get their feedback from your managers and supervisors about it, because they may say, hey, this isn't how we do it anymore. Either you need to change, that needs to change so that they become in compliance with the handbook, or maybe you need to update the handbook. I even encourage, if you don't want to pay outside counsel to do it, have a colleague, a human resources colleague from another company. It's not a violation of confidentiality to have another colleague review your handbook. Have a spouse review your handbook. Somebody who's not even part of your company. Read it. Tell me, does this make sense? What do you think about it? If you were an employee, what would you think about this handbook or this particular provision? I think that in terms of the employee handbook, the key is you want it written in plain language and understandable. This handbook really is, it is for the employees. It's for the company as well, but it is a document for the employees. It should give a general expectation of the company's policies, procedures, requirements, standards. You've got to have the at-will and disclaimer notices in there. I think one mistake I see sometimes is I'll get a handbook to look at and revise or make suggestions to, and what I'm getting is like a detailed policies and procedures manual that might be more appropriate for, and this is usually in a larger company, for a manager or supervisor who's managing 20 or 25 people on his or her own. And that's not necessarily something that you want to communicate and disseminate to your entire workforce. It should not necessarily be a policy and procedures manual for human resources or a manager or supervisor. It really should be a general overview describing your policies and in language that your employees can understand and will get some value from. You want to review your at-will employee language. As I indicated before, you want to have those disclaimers in there. There's some Connecticut case law that talks about, if you don't have these disclaimers in there that talk about the at-will nature, that talk about the fact that the employee handbook doesn't create a contract or any guarantee of employment, that the employer, you want to have language in there that the employer can modify the policy without any notice, that the employer retains discretion to make decisions that are appropriate under the circumstances, and you have the authority to deviate from that policy. You need that language in there. An attorney can help you with that language as well. You want to be careful in how you describe the employees, and I was going to talk about this in a bit, but one of the issues that I see is, and I always kind of question, is this concept of Well, we have probationary employees. Employees in their first 3 months are probationary employees, and then once they pass that probation period, they become quote-unquote permanent employees. There's no legal definition of a probationary permanent employee, but that term permanent employee can be dangerous, can be used against us by a skilled, crafty plaintiff's employment lawyer that, well, all right, my client has gotten through his or her probationary period. That would suggest that they've attained a certain level of job satisfaction or performance. They've now labeled under your employee handbook to be a permanent employee. They maintain that they've continued at that same level of performance, and you've now terminated them. And there's a question of fact now as to whether, was their expectation that they had retained this level and become a permanent employee, and that they had to, their performance had to go below some certain level now in order to be terminated. I really don't see the value in having that probationary employee versus permanent employee concept in your handbooks. And my own view is that it is sort of an antiquated approach. It also sort of raises it's sort of a concept that is more akin and more pertinent to a collective bargaining agreement, like in a union environment. A certain person may not become eligible to join the union until they've reached probationary or gone through their probationary status. And up until that point, they can be terminated at will. And then once they become a permanent employee, they now are under the just cause provision of the collective bargaining agreement. And you arguably have created that scenario by using this concept of a probationary employee. Some of the language that I've seen in this in handbooks that, and I've kind of, as I've gone along for years, kind of used some of these or kept some of these quotes, but I've seen things in handbooks. You will always be treated fairly at our company. Not a bad concept to adhere to, but I don't know that we need that in our handbook. A skilled plaintiff's lawyer is going to say, well, all right, you've created an expectation that I can challenge any decision on fairness. What does fairness exactly mean here? Other language, any decisions about discipline or firing will be fair. I think people are sometimes surprised to hear that under at-will employment, I can make an employment decision that may not meet some general concept of fairness, but it's not illegal. As long as it's not discriminatory, and as long as it doesn't violate some specific public policy, or it's not retaliatory, then whether it's viewed through business ethics or through the eyes of the employer is fair or not fair, the court's not going to get involved in that. That's a motion to dismiss. That case is gone. And no plaintiff's lawyer, I say no plaintiff's lawyer, but most plaintiff's lawyers, most good ones, they're not going to take that case. But you don't want that language in your handbook. I haven't seen, this wasn't in a, it wasn't in a handbook, but I've seen this in a letter to an employee in discipline. If you work hard and you do your job, you will always have a place here at our company. Not a bad concept, but not something you want to have in writing in your handbook or in a letter to an employee. Employees will always be rewarded for their hard work. Again, an expectation that you don't need to have in your handbook. Keep doing what you're supposed to do and your job will be safe. I've seen that, sometimes in letters from managers or supervisors. That's arguably destroying the at-will relationship there. Seniority will be considered in all seasonal layoff decisions. You've now basically bound yourself to something akin to a collective bargaining agreement provision. So you want to be careful there. And then, like I said, I do see handbooks that talk about the employer will terminate for just cause. You don't need that in Connecticut. So obviously, the major goal with our handbooks is consistency. We talked about reading it, discussing it. Ask your employees if you have some employees that you have a good relationship with, that you trust. and you want to talk to them and ask them, what do you think about the handbook? Anything that you think needs to be clearer for employees, or we could say better in the handbook. I think that the problem areas that I see with handbooks in terms of inconsistency are progressive discipline. You know, everybody thinks it's a great idea to have a progressive discipline. We're going to do warning. We're going to do written counseling. We're going to do warning. We're going to do final warning. Then we're going to do suspension. Then we're going to do suspension without pay. Then we're going to do termination, and we're going to have that, and it's going to be clear for everyone. It's a great concept, but if you don't follow it and you're not willing to commit to following it for everybody, you are probably better off not having that progressive discipline policy and having a more general policy that allows you to use those concepts in terms of coming up with discipline, but having discretion depending on the circumstances, depending upon the type of incident that's involved or violation, talking about the employee's history at the company, and giving yourself a little bit more discretion in terms of how you are going to approach discipline. I also see, you know, a lot of times I'll see language about paid time off and how paid time off is going to be handled. And then when I go and interview the managers or the human resources person or take the deposition of the employee, or the human resources person is being deposed, and we find out that the company handles paid time off entirely different than what's in the handbook. And you want to make sure that your actual policies on paid time off are reflected in your handbook. The other one I see a lot is, you know, there was a time period where flex time and flexible work schedules was kind of in vogue, and there was a real push to go to flexible work schedules. I've seen some kind of, well, with COVID and work from home, it's kind of a toss-up now, but you know, I've seen a little bit of backtracking from the flex schedules, but a lot of employee handbooks still have language about your ability to request a flexible work schedule, that we encourage flexible work schedules, things of that nature. So I think those are issues or areas to pay attention to. I wanted to talk a little bit about some handbook policies or language to avoid. I mean, here's another one that I don't always understand why we want to have this in our handbook. We have an open door policy here at Halloran Sage. I mean, what does that, you know, what does that really mean? Is there a better way to communicate that to our employees than, you know, kind of labeling it as an open door policy? Is it really necessary? We could have an open door policy, but we don't need to bind ourselves to this policy in our handbook. I think some of the risks that it creates is, you know, does it mean then that if the employee comes in and shares certain things about what they're doing, what's going on at the company, that we can't then as a manager, because the manager kind of encouraged this sort of confessional, if you will, by having this open door policy, that then the employer can't use that information if there's a need to take discipline against that employee or against another employee. I think it also sort of encourages dependence on the manager. I think there's some employees who believe, maybe a weaker performing employee who believes that, well, because we have an open door policy, I can just go to my manager with every single problem that I have at work and they'll solve it for me because they have an open door. You know, I've even heard people say, well, my manager's door was never open. He violated the open door policy. I mean, taken to a literal sense. But you hear that. I mean, you hear that because you'll ask an employee, a plaintiff in a case, you know, well, how come you never went and complained to your manager about this? You know, well, his door was never open. And, you know, we had an open door policy, and he always kept his door closed, so I never felt I could go in there. I just don't know whether to me, it's something that, you know, you're almost creating this dependence as your manager becomes sort of a therapist. You kind of divide, you've blended the line there between manager and supervisor with this concept of an open door policy. I think you also have to be careful with policies. I've seen policies that state that, that the employee will reimburse the company for damage to property, damage to equipment, lost money, and that the company will take automatic deductions from pay for those damages. As we know, under Connecticut law, we have to be very careful about any sort of deductions from employees that are not authorized. And even sometimes when we have their authorization, we run into trouble with the Connecticut wage and hour laws. So you want to be mindful that, you can't just go, you shouldn't just go and dock employees' pay for damage to equipment, for lost money in a cash register. You really want to scrutinize those policies if you have them. It's also, you don't want to have, I see language sometimes in policies that conditions final pay on return of company property, on reimbursement for health insurance payments. You want to be really careful with that language. Anytime you're going to deduct someone's pay, kind of bells should go off about, can we really do this? Because in most cases, under Connecticut law, you cannot dock someone's pay for that type of thing. And you certainly don't want to have policies in your handbook that reflect that. We talked about the probationary policy. What does that really mean? Does it confer special status? So,
Hey, Kevin.
Yeah.
Can I interrupt you for a second?
Sure.
Look to your left. Here I am. So I just want to interrupt you because your slides are really great and they're really helpful. And I want to keep you going in case we've got questions. And so before Kevin continues on with his slides, does anyone have any questions so far about anything that he's said or anything that you're wondering about with respect to handbooks? Okay. Oh, hold on one sec. Oh, sorry.
Good morning. I was just curious with the whole COVID situation. They told us in advance in January that we should have a COVID policy in our handbooks in reference to the administration announcement that we would have to, whether test or be vaccinated. And now that that's out the window, should we have anything related to that? Because it's ever changing, and that's where I struggle right now.
Yeah. So that's a really good question. And, my feeling has been, and what I've been telling employers is, let's wait to put those COVID policies into the permanent handbook. Let's keep those as sort of separate policies for now, because as you pointed out, they are so dynamic, changing literally to the day, to the week, to the month, depending on what particular court case comes out, what executive order is either extended, and to try to go and keep that actual handbook, your core handbook, updated for all of those changes is difficult. The way I've been recommending the approach to COVID is, let's have separate policies, and then if something changes, let's just update that change. In terms of the ETS, the standard, we were spending a lot of time developing and creating policies to address the standard and how we're going to treat the vax or test mandate, and that basically went out the window. So if you have that policy in your handbook, my recommendation would be to take that out, unless your company has chosen that you're going to implement a mandatory vaccination or test policy. You can still do that legally, as long as you do it in a way that's compliant. You can still enact that as a policy, but you're not mandated by law to do it. My recommendation has been that perhaps, maybe except for some general guidelines on safety, that, if you're still having symptoms, if you've tested positive, what rules are in place there in terms of return to work, you probably want to incorporate those into your handbook. But all other COVID-related issues, I would say keep as separate, kind of day-to-day, week-to-week developing policies that are communicated to employees and signed off on, but not part of your core employee handbook.
Yep.
Yeah. I can hear you.
You mentioned a probationary period. We're not a unionized environment, but we do have a clause that says that you're going to your performance will be reviewed in the first 90 days. Is it okay to keep that in the handbook, but not use verbiage as stating that you're going to be moved to a permanent employee status
I,
after 90 days?
yeah, I think that's fine. I think yeah, so the question is that the employer's handbook has a provision that states essentially that after 90 days that you'll have a performance review and that there'll be a comprehensive review of your employment or of your performance. And I think it's a great idea. As long as you don't have language in there that confers some special status by getting through that period, either permanent or probationary, then I'm fully on board with that. In fact, I find that, employees want to know about what the performance review process is. Like, is it yearly? Is it every 6 months? Can it be kind of ad hoc on a case-by-case basis? And I think the more you can tell them about your performance review process in your handbook, the better. So I like that idea. Yeah.
I have a mic.
I got a big mouth like her. So when you were talking about the signatures on the policies, if you have a payroll software that includes those documents and they're signing off through that software, is that the same issue as an email, or would that?
So I like that better. And I think, what I would make sure is when you contract with that software company, or if you've bought the software and you're using it, I would test them on, well, show us what we're going to get for documentation to show that this person clicked. And there's a term that they use. It's like click and wrap or something like that. That they can show. They'll produce a document that will show that that person scrolled through the policy, clicked a box at the end acknowledging that they have scrolled to the bottom. Some of the software doesn't allow them to actually get to the next screen and sign off until they've actually showed that they've scrolled through. And my understanding, this is getting a little bit detailed in response to your question, but my understanding is that there are even software that's built in that, if the read time of the policy is 20 minutes, they'll actually not allow them to click until the software can show that a minimum of 20 minutes has passed. But I would really demand of your software provider to show you what documentation are we going to get that shows that people read it. What's the e-signature going to look like? How do we know that they actually read it? So I think that policy or that practice is fine, but I would make sure and scrutinize that the software is going to be able to produce a strong document or proof that all the employees got the policy, read it, and signed off on it.
Kevin, we have another question.
Yes.
Hi, good morning.
Good morning.
My question is, when you were talking about, right now currently we have a policy because our employees do have a lot of equipment that they keep at home. So we do actually have a policy that says if you are terminated or you decide to leave, those items need to be returned to us or your pay will be docked. Obviously, from what you just said, we shouldn't be saying that. So what would you suggest? What would you suggest that we do use as terminology to ensure that we do get that equipment back? Or obviously we can't dock the employee. What do you suggest for an updated policy?
Yeah. So I guess I'll point out that saying that your pay will be docked is not per se illegal. It would be the docking of the pay that would be illegal. So you could have that as kind of the big stick over their head. As long as you don't hit them over the head with it, you haven't created any legal problem for yourself. Language that I would prefer is that the employee is financially responsible for the return of the property. And I'll have to say, I'll have to admit that I have actually brought suit on behalf of companies who usually more expensive type equipment. Even I had one case where it was a vehicle, that we actually sued the person for the value of the vehicle that was not returned, or the value of the property. So some language in there that the employee is financially responsible for equipment or property that is not returned to the employer at the conclusion of employment gives you the ability to do that. I think it's the deductions from pay or deductions from wages, kind of the automatic. That's where the problem is created. But you can still pursue that claim against the employee. I was going to turn to, I know that we're kind of not running out of time, but I'd like to move along to just reviewing the sexual harassment policy that I included in there. I think, the key components to a sexual harassment policy. Yes.
Keep sticking with questions. We've only got about 5 more minutes.
Oh, okay, sure.
If you take a really hard look at your materials, Kevin's materials are really very thorough, and I think you'll find a lot of the information you need. So we're just going to stick with questions, and we're going to be about 5 minutes beyond what the schedule shows in your materials. So we're going to end here at about 9:45 and then take a break until 10. But I've got a question for you here, Kevin.
Sure.
I just had a quick question as a follow-up. If you were to have a sign-off sheet where the employee signed off giving you permission to deduct from your final check an amount of the value of, let's say, a uniform, as long as you have that sign-off with the authorization, does that cover you, or you're still saying no?
I think you're in a lot better shape with that. But keep in mind that, technically under Connecticut wage and hour law, any deductions are supposed to be approved and presented to the Department of Labor to notify them and get their permission if you can get a response from them. And I don't mean that in a critical sense, but there are times when those submissions go in and it takes forever to get an answer on it because of their workload. So I think that, that puts you in a much stronger position to defend legally. It's hard for me to give you an affirmative, yes, you can do that. If you went the extra step and got the Department of Labor's imprimatur, authorization, permission to do that, then you're in pretty good shape. My understanding is that they're fairly restrictive in the circumstances in which they'll approve those types of deductions. I was wondering if anybody had any questions on work from home and remote work policies, because I think that, although we're hoping that a lot of these COVID policies are going to kind of go by the wayside, knock on wood, I think remote work and work from home is with us probably forever in some form or fashion. And I definitely would recommend that you start to think about and start to talk about including a work from home, remote work policy in your handbook. I mean, it is so crucial to the employment relationship, the idea of, where are you going to actually work and how is it going to be handled, that it's something that should be in your policy. And I think that it will also help you avoid some of the problems that we've seen from work from home already in terms of wage and hour compliance, in terms of responsiveness and communication, in terms of, one of the things that we're seeing is that when people are in their homes and not in the work environment, they may feel more comfortable kind of stepping over the line of sexual harassment type policies. And I think we need to remind our employees that, when you're working from home on a Zoom, working from home, email, whatever the case may be, that our sexual harassment policies and our other policies and procedures on conduct and communications still apply. Just because you're sitting at your home, it's just as if you're in the workplace. Sexual harassment remains illegal and is not going to be tolerated at our company, and I think that needs to be communicated in our work from home policies.
Okay, I've got a question about that here.
Good morning. We actually are in the midst right now of developing this policy for our handbook. The question I have is, can you segregate work from home or remote working for salaried individuals versus hourly individuals, or does it need to be all-inclusive?
So you certainly can have different policies that would apply to work from home for a salaried employee versus an exempt or a non-exempt employee. So yeah, I mean, there's nothing legally that would prevent you from having different policies. And I think, you probably need to have different policies for that timekeeping aspect of things. If somebody's an hourly, non-exempt employee, you need to make sure that you have a way to keep track of their hours. And you probably need something beyond just sort of, I logged into my computer. I know that there's software now, there's different apps that employers are using, and we may have some people here today that can give us information on that. I don't have the names of those apps and those vendors, but timekeeping is certainly an area where you would probably want to have a different policy or need to have a different policy depending on the exempt or non-exempt aspect of the employment. I've also found that I think for sort of rank and file, non-exempt employees, there's not so much, the work from home isn't so much of kind of an optional basis, whereas what I've found is with the exempt executive management type positions, there's more flexibility in that, they may choose to work from home for 2 days and then come in for 2 days. It's a little bit more ad hoc, whereas with your rank and file, you may require them to formally get permission. And I kind of outlined in the policy that I provided what that procedure could look like in terms of getting permission and what different factors and considerations are in place. I think the important idea is that work from home it's a privilege. I think a lot of folks are looking at it as a right. I have the right to work from home. Because of COVID, I have the right to work from home. Arguably might have been true for a period of time, but not anymore. This is a privilege. And look, we know that it's a privilege that we're probably, in order to have the employees that we want to have, we're probably going to need to be flexible and accommodate it and allow it. But it is a privilege, and that privilege needs to be and can be defined and controlled by the employer. And my recommendation is that we do that with a written policy on work from home or remote work.